All right. Hi, this is Curt Barone,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for September 1st of 2025. Brad, go ahead.
Happy Labor Day. Okay,
Happy Labor
so
Day.
if you looked at Kurt's blog, you're going to see at some point, and maybe we should leave it to last so we can give it more time than or as much time as it should be due, is the antitrust claim against the truck manufacturers.
Yeah.
So I might go on some order, trying to get rid of a couple of things, and some I'm going to go more in depth than you might think I
Well,
would.
and
But
I
let's,
don't think we're going to get rid of anything because there's a
oh,
really a smattering of really interesting cases here that, each of them, we could do an hour on each of these.
oh, I agree,
Yeah.
except maybe for the first one. Let's start with the
Well,
Ohio.
you and I have talked about this one. This one there's a lot more going on than what's in this one case, but
Agreed. So, okay, so let's start off. So,
okay.
we have an Ohio appeals court who
Mhm.
reinstated a defamation claim. And in this case, it's called defamation per se, which is when you accuse somebody, in this case, of perhaps a crime.
Mhm.
And that's important to lawyers. I'll get into the facts, but just setting the stage, it's important to lawyers because you don't have to prove actual harm to yourself, as opposed to regular defamation. You said something generally untrue. You got to prove how you were harmed. In any event, so we have the Ohio Appeals Court who reinstated the defamation claim by a former chief of the Port Clinton Fire Department. So, and they got rid of some other stuff. But so here's the basic facts. So this chief served with the fire department since '92, and he was the fire chief since 2008. He was placed on administrative leave in 23 following allegations that he sexually harassed an EMS employee. Now, start off the bat, a lot of times we get false allegations, and I'm not saying these aren't, we don't know, but a lot of times you get false allegations, and the one who's accused is the victim. So what I like about what he's doing is saying, I'm going to go on the offensive to protect my reputation, not just defend, oh, I didn't sexually harass anyone or whatever, but he's going to go on the offensive. And so we'll see how he does that.
Mhm.
So a city had referred the matter, which I like, to independent investigator, right, to investigate the sexual harassment. And then the Bureau of Criminal Investigations also was looking into related payroll issues, right? It's like when it rains, it pours. We're not going to come after you on one thing, we're going to come after you for another. So ultimately, the chief was notified of a pre-disciplinary hearing on charges that included payroll irregularities and the sexual harassment claim. And you're wondering, well, how are they related? Well, they're related because I think he said they were, was it paying off something or using the money improperly related to the alleged sexual harassment? I know we'll get into it in a minute. But so I'm not totally sure about that part. In any event, he files suit. He had 6 claims, but all were dismissed except his defamation claim. Now, this is the part that's just little. It's not a big deal. He doesn't win. He just won at this stage. And all the court does is say, well, the complaint that which is just, you just have to put the right words in there. It adequately alleges defamation per se. And that allegation is that the city statements that he intentionally misused public funds and engaged in sexual harassment. And the judge says, you've said enough. Right? You said enough that you alleged enough that they published these false statements with the intent to harm you, which is what we call actual malice. And that's important. So that got sent back to the trial court and that will proceed. And now that will go forward on a question of fact. I said this, I think, on the last one or the one our show before this. I have sued 3 defamation cases and I lost all 3, and I will never do another one again unless it's so extreme. They are
What
very difficult to win to prove
did you
someone
get? Did you get to the factual allegations, or was it dismissed on the way to trial?
No, we got to the pleadings because in New York anyway, and I assume many other states, you have to state exactly what the defamation is, and then the judge gets to make a determination as a matter of law, right, without a jury trial, that if what they said, you said is true, if what you said, they said is
If you can
true,
prove it, right?
right, if you could prove it, does that amount to it? And the problem is almost all defamatory, there's 2 problems. One, almost all defamatory comments can be thrown off as an opinion. An opinion is not actionable. You can't sue on somebody's opinion. So, and you see people getting cute. I think you're a thief. Or when somebody says, oh, you're a thief, but didn't say because you stole $100 from my desk, they just say, oh, you're a thief. Well, that's more of opinion, right? Even though they're saying you're a thief, which is defamation per se, arguably, because you're accusing someone of a crime, you're really not. You would have to say, oh, you're a thief because you took $100 out of my desk on this day. That would be true, or it would be defamation. But usually it gets dismissed out of, out of opinion, right? They say it's an opinion. And the second part that's very difficult to prove is actual malice. And here, if the employer, the fire department, proves that that all they were trying to do when they said these things was protect a victim of sexual harassment, that's no malice, right? They're doing their job. And if their job is required by statute, you can't sue on it, meaning we have to investigate, right? And we were just commenting on an alleged allegation. And again, you could use words, loose words. I allege, I believe, or I opine. That's not defamation. But he got past that stage. So that's the big hurdle. Now he's going to go to a jury because presumably what he said they said is enough as a matter of law. So that's a big deal.
Well, she is suing, the victim is suing, and I've got some of the links to our earlier coverage of this case because this one, I think I've got at least 4 or 5 entries on this one little area, point in time in this particular fire department where he's been disciplined, he's suing, she's been sexually harassed, she's suing. He's got criminal charges facing. He's apparently the criminal case is wrapped up, and he's been sentenced to 180 days for a lot of things. You can read. I don't want to get into the details of it, but I mean, he's facing now. There's a question about whether or not he's actually going to serve it or it's going to be home
But if he's
confinement.
convicted and they accuse him of a crime and he's convicted of that crime, then in fact the allegations are true.
I was not able to determine if he pled guilty or whether or not he was convicted, but he has been sentenced, and I've got a link there to some additional information about that. So that certainly offsets. And I think, he had 6 claims. He lost 5 of them. He's got the one defamation, but, there'll be a factual question about whether or not what was alleged to have been said was true or was not.
Right.
So
okay,
not a good situation for that department or for the victim or for the chief either. I mean, it's
and this will go on for another couple of years, possibly, right?
Well, I did go on the federal court through Lexis, get into the federal court status of her sexual harassment claim, and it still is going on. It sounds like they're having some discovery issues in terms of him possibly, whether he's in custody or whether he's not able to produce some of the documents. There's some discovery motions, and they apparently just reached an agreement on discovery and gave some deadlines out. But 2 years into her lawsuit, and it doesn't seem like it's anywhere near being resolved.
And I'll tell you, more people, and people have asked me in the past, well, I want to, she's accusing me of sexual harassment or sexual whatever. I want to sue her for defamation. I'm like, you can. However, the risk is, A, a jury looks at you as retaliatory, and B, if she wins on the harassment, now you've added retaliation on top of it by suing her. I said it's a risk. Sometimes I say better just to get rid of it and suck it up. But I see people wanting to sue for defamation, and it's just so very hard.
It's just such a mess, such a mess for everybody involved in this. So.
Yep. Okay, the next one, I'm going to catch you off guard a little bit because I'm going to go, once we get through what you have on your blog, I'm going to go a little more in depth into the complaint for an incredibly interesting issue that was present in this decision, or more in the decision. So here we're in Cincinnati, Chip Comstock's semi-romping grounds, and we have a U.S. trial court judge has ruled that the city of Cincinnati violated the due process rights of their former fire chief when they summarily terminated him. And look, the facts are super simple. The facts are he served more than 6 months on the job under the city's charter. Once you serve 6 months, you're not probationary. You have a vested job interest. The court holds, like many, many courts have held, that once you have a vested job interest, you have a property right, and thus under the 14th Amendment to the U.S. Constitution, you cannot be deprived of your property rights without due process, right? It sounds like a lot of cases we have with me. usually that would be, this decision would be, it's another one of many, right? Another one of many saying you got to have a hearing. And they didn't give them a hearing, and I got to explain two terms. There's a pre-termination proceeding and a post or an after termination proceeding, which we call post deprivation, right? So after you were deprived of your rights to your job, can they give you a hearing? Now, I hate this law, but this is universally true, I will say, across the US, is that if you get and this is what the court says, if you get a somewhat good but not perfect set of hearings and due process, and then you show that, well, it wasn't perfect, and they send it back, you don't get money, right? But they can send it back. And that's called a post-termination right. And this is going to affect a lot of our viewers, certainly this next part. But if they got nothing whatsoever, I argue in some cases, and that's what I want to talk about soon, I argue in some cases, how can you get a fair hearing if we go back? So
we can't go back to the same person.
But that's what they wanted to do. Yeah, so here, they wanted to go back to the same person. Right. And they wanted to go back. If that person failed, there could be an appeal, right, to a more neutral person. So this person doesn't want to go through it, doesn't show up. And you have the question here of, okay, and let's talk about this generally. Forget the facts. Well, forget about the facts of this case, because they give two other scenarios and then say this case is right in the middle. So this is what's interesting. So, and I've had this, I've lost on it once, and I'm hopefully going to win on it here. But when you have a hearing and you can replace the arbiter, right, the person who's going to judge you, with a neutral party, the rule is for the judge, fine, we'll give you some damages, we might give you some attorney's fees, but you're going back and you're going to have the hearing. What you don't want to do, people, is say, well, that person's not neutral, so I refuse to go to the hearing. If you do that, which wasn't this exact suit, this is one of the cases on the left that they cited, they say if you don't go through the hearing, you lose because you should have gone. And just because you claimed they were biased doesn't mean that you don't have to go through the hearing. But then they talk about another case where there is total bias and there's no chance of you getting a impartial. And they say, okay, there you could appeal before the hearing and say, I don't think I could get, right, an impartial hearing. And if the court rules against you, basically you can go back and start the hearing. My advice to everybody is go through the hearing. Yes, it could waste a lot of time, a lot of your time. Don't ever skip the hearing because you say something's not neutral. And the judge, I want to read a long paragraph on this point, because this is what I think is the most interesting part of this case. Right? I mean, look, they held he has a due process protected right in his, in his job, and they said that, the city violated his rights by not giving him notice of charges and an opportunity to respond. Right? But the question is, now what? And this now what has been plaguing me in my own law practice, presently waiting for a court decision on this very question. So, and then there is a factual dispute. This is the point we're going to talk about, whether the chief was denied adequate post-termination process, right, when he was offered hearing before the same official. So look, they just got to give you someone else, right? But listen what the court says, and I want to talk about it. This is very long, but let me read it. Does that mean, says the court, that the chief, I'll supplement some phrases, was permitted to skip the hearing in front of this non-neutral person, and seek recovery in this court for the post-termination violation of being terminated? That is a much closer question, says the court. A plaintiff who elects not to participate in a post-deprivation process that is offered must prove that it would have been futile to participate. And they cite a case, and they go through some others. And let me just read this next paragraph, because this is so important to people, especially if you're in New York and a couple other places. I'm going to say why. The court says, the facts of this case fall somewhere between Nichols and Rogers, two different cases, in which no post-deprivation process was offered at all, and in Hyber, in which the plaintiff began a comprehensive post-deprivation hearing before a three-person panel, but later abandoned the hearing. On the record presented, says the court, a reasonable jury could find that the offer of a post-deprivation hearing before long, the non-neutral guy who terminated him in the first place, was so inadequate as to be no meaningful process at all. But, he goes, based on this other case, a reasonable jury might also conclude that the chief's refusal to participate in the post-termination hearing that was offered before this non-neutral person was an unreasonable abandonment of his post-deprivation due process rights. In short, genuine issues of material fact remain regarding the adequacy of post-termination hearing and waiver. So I want to talk about a case I have with regard to this. So here's what they say. In short, the best advice, don't ever skip the hearing. Don't ever skip the hearing. But what do you do when there's a statute in New York, in many other states, I guarantee you'll know it better than I. What do you do when the law mandates that a 5-person, a 3-person panel is the only one who can render a final decision? So in New York State, and I have this, I'm waiting for a judge's decision right now. And the law also in New York State, the highest court has said, and many other states, because I've cited it, Ohio, by the way, because I quoted an Ohio decision in my case that Chip Comstock gave me, has also said that when you have to go to the same place, and they've already, same people, same arbiters, and they've already made a public statement on your guilt, right? Not privately. They've publicly announced their belief in your guilt such that they've bound them to that position. Then they have to be removed, right? But what do you do when there's no one to remove them? So in New York State, and in many other governments where the governing board, the city council, the village board, the town board, when they're vested by state law with making the decision, and they've already gone on record saying, I think you're guilty, how can you ever get a fair hearing? So I have that now where in New York State, a fire district's board of fire commissioners under the law has to make the final decision. You can't replace them with new elected officials, right? There are no other elected officials. So we've argued, they just put in court papers which says, we've determined, we know, the facts are this, it is clear that, using those words, all ending with, he's guilty, the chief is guilty. And I've argued now, just as in this case, how can I get a fair hearing when you can't replace them? And that's the issue. I think that this case, right, it's not exactly that. They can replace that one person, so don't skip it. That's where the court's saying, don't skip it. But what do you do when you can't replace the arbiter?
Yeah. Well, there's so many things. I've been trying to keep track of the different things that you said that made me want to go off in a different direction. But part of due process, a fundamental part of whatever part of due process we're talking about, procedural due process anyway, is that the adjudicator, I call the person the adjudicator, okay? The adjudicator is the person who makes 2 decisions, one, guilty, not guilty, and then if guilty, what's the appropriate penalty? So there's the 2 fundamental adjudicatory decisions that neutral has. And a fundamental part of due process is that the person who's serving as the adjudicator or the panel, okay, and I've got cases that say if you got a 5-person panel, if one of them is biased, it's a due process violation.
Oh,
okay?
Send that to me, please.
1 out of 5. So all it takes is 1 out of 5. Or 1 out of 10 or whatever. But the problem there is the deliberations that take place. You have a biased person taking part in the deliberations that poisons the remainder of the group.
You can't just recuse them, stay out of the process.
Exactly. That's what you have to do.
Okay.
And they can't recuse and go into executive session.
Right. Recusal means get up, get out.
Recuse means stay out of it totally. Okay. So really fascinating issue on that part of it. When we think about due process, if they give you a process and you don't take advantage of it, how can you claim that the process wasn't fair? Because that's what you're saying in due process. So you got a little bit of, a paradox there. There's a paradox in terms of how you handle it. Okay. But I do want to point out to me, what stands out here is the Loudermill issue, which is the right of an employee who is not at will, and that's what that 6-month probationary period cleared him of. He is not at will, okay? He was terminated before he was informed of the charges and given an opportunity to explain or rebut. That is a Loudermill violation. That is clear-cut, slam dunk. They violated his due process rights, regardless of the post-deprivation process. That is a due process violation. So the chief's due process rights were violated, slam dunk. Now we move into the post-deprivation process, and I would be arguing if and I'm sure his attorney argued it, is that there's no amount of post-deprivation process that you can give me that can clean up your Loudermill mistake.
Right.
Okay. So I win just based on that. Okay. Now, fine. We'll play this game with the post deprivation.
But don't skip the hearing while you make that argument, because you risk that the court
I get it.
disagrees.
And as you said, there are some cases where the courts say that you're not required to go through a futile process. Okay. But how do you know it's futile until you've gone through it? So there's, again, paradox there, and they'll have to work that out. There's cases that go both ways on it, like you said. So, but I think what to me is clear in this case is his due process rights were violated. There's going to be some damages. City, you might as well just come to the, get up to the table here and figure it out. They're talking of there's some additional news articles this week now coming out that they're going to take it, they're going to appeal it and tie this up 4 or 5 more years through appeals, and how it goes back and forth and back and forth. So
it's an unfortunate tactic, but if you change the facts one bit, and let me say, so when you have actual damages, then you can get attorney's fees. That's generally the rule. I will say most states. I can't speak for every state. Right. But if you have only nominal damages where, well, I really didn't suffer, I was paid during the whole time or whatever. Right. So change it. Now make this fire chief a volunteer. He has no real damages. So the question would be, do you get your attorney's fees? And if not, them dragging this whole thing out makes it unaffordable. So there are rules. New York has one. I know Ohio has one because I quoted it. Ohio had a whole depth of good law for us, even in New York. But what do you do when you only get $1 because you're a volunteer? You didn't lose any wages, unlike this chief who's terminated, right? Can you get attorney's fees? And there's federal law and state laws or cases that say if no attorney would take this because there's no value of it, but you prove a civil rights violation, we're going to give you attorney's fees anyway, right? Because they have to discourage, right? So for the paid people listening, okay, this speaks to you, but I want to also throw in the volunteers here. Same laws protect you, but you still could get your attorney's fees.
And I think it's important to point out that New York has that unusual law that gives volunteers a due process right by statute, not constitutional, by statute.
But Firefighter Bill of Rights in some states
that's usually career firefighters. I'm not aware of a Bill of Rights that applies to volunteers. But the point being here that the volunteers do not have a property interest in their continued employment. Whereas in New York, you have that statutory due process right. So that takes the place of the property right. And I think there's a factual question in New York anyway, about whether or not you really need to have a property loss in order to prevail.
No, and you don't. You don't.
Right. And you shouldn't. And that goes to your point there that there ought to be attorney's fees attached to that. Otherwise, how do you enforce it? It's a theoretical right that it's not enforceable because no volunteer is going to spend $100,000 to vindicate being thrown out of a volunteer fire company. So it's a paper right, but it's got no value.
And the union side, right, for your paid people, if the union were paying for this, they don't have unlimited funds at the local level. So they need, a rule of law that says you get your attorney's fees. And you would in 1983 actions, you get your attorney's fees when you sue.
The unions are primarily, they're biased in favor of grievances. And I think that's the reason is that it's less expensive. It's less burdensome on the local, especially smaller locals.
So anyway, I think the whole point that I get from this case is even if you think the people are biased, don't skip the hearing. It costs a little more. Go through the hearing, make the record, and then argue you couldn't get a
Right.
right? And then you're actually in better ground because, and then I'll get off this topic, you get a ruling that's identical to the first one. Say, see, same issue, right? No new change, same result. It was bias. So go through the hearing, don't skip it, even if you guys think you're right. Okay, let's go to North Carolina. This is probably I mean, it's long, but it's not as in depth as we just did. So we have a lawsuit for discrimination in North Carolina by a firefighter, and all that's happening is it's getting moved up to federal court. Now, I shouldn't say this. I don't like federal court. Now, Chip Comstock, some lawyers love federal court. It's predictable. It's very well run. It's timed. There are no delays. Some state courts follow federal courts very quickly, but, and you got to be admitted to federal court. And if you're not in federal court all the time, right? So I don't like it when my cases get removed to federal court. Most times I'll hand it off to another attorney. I'll say, I'll consult with you, but you're doing all the stuff. In any event, we have this lawsuit, and it alleged disability, race, ethnicity discrimination. It's the facts in this case which are so interesting, not the law. Because as I'm starting to read the facts, and I'm going to go through them, I'm like, come on, this is not a lot. And then you see it, and you're like, oh, this is getting to be a lot. So we got an Hispanic firefighter. He begins working in 2018. He was hired as a firefighter 2. A couple of months later, after he's hired, 1 month later after he's hired, he sustains a workplace injury doing a certain task. And let's just say he's doing a certain task. This is going to come back. And his tendon was injured from his elbow to his right shoulder, kind of retracted, pulled back, I guess. He was placed on a 2% permanent disability, but permanent, meaning he's right. So, and I thought they were just going to go and say, well, you can't perform the essential job functions, but they don't do that. In any event, so he's out of work for 4 months. He couldn't lift more than 10 pounds, but then at some point he's cleared for duty. All prior restrictions were lifted, which is weird because he's got a 2% permanent disability, but it apparently allows him, I assume, to keep doing the essential job functions. So he goes back. Now, jump to the end for a second. He's claiming they're discriminating him based on being Hispanic. Okay, so he comes back from leave, his first day. They gave him the exact same assignment that caused his injury. Now, I don't know what
he's in the academy, Brad. He's in the academy.
So he's got to go through it.
He's been in the academy 3 weeks. He gets hurt, and they say, okay, you got to go back through the next academy.
Right.
So, well, what do you expect? You got to put it. You've got to be able to do it. I'm really skeptical about these allegations. I got to be honest with you. Somebody who's hurt the 3rd week of the academy, and then is characterizing what happened. They gave you your job back. You were hurt. You didn't finish the academy.
Right. But I agree with you on that until we keep going, if true, right? And as Curt and I always say, we don't know. These are allegations.
Right. We don't know.
Right. But so that's why I was saying, like, I agree with you. Of course, he goes back. He's got to start from the same place. Of course you're going to. In any event, but he then requests permission. Now, I think this is a little who cares as well, but it keeps getting worse. He requested permission from his employer to film a video for a nonprofit organization that's related to Hispanic Heritage Month. Now, I, as an employer, might say no as well, because wait a minute, we're not a circus, right? We're here to work and do a job, and you're distracting everyone from their job. So maybe not. In any event, so he says that, and I was like, that's not a big deal. But then his request was to allow a cameraman follow him around recording his day-to-day tasks. I could see an employer saying, I don't care whether what the purpose is, right? But it keeps getting worse. So then he claims he constantly heard discriminatory commentary coming from a captain, and says, I don't want to hear about your culture. For all I know, maybe he was throwing it in his face, right? Saying, well, Hispanic this, Hispanic that. Maybe the captain said, look, I'm tired of you talking about it. Okay, maybe. But it gets worse. So then he alleges that he was subjected to continuous negative and derogatory comments about the Hispanics and immigrants, Spanish-speaking people. And he says, the captain, now this is a problem. The captain says,
I agree with you on this.
Right. He doesn't want him to speak in the Spanish language to others, and that he was alleges that he was prohibited from speaking Spanish. And in one instance, in 23, a lost child came in who was Hispanic. His first language, right, was Spanish or whatever. So the plaintiff spoke to him in his native tongue, Spanish, to gather information about him. And he was then allegedly able to be reunited with his mother after being being able to talk, right? Talk with him. But allegedly, the plaintiff was scolded by the captain because he said, "You're keeping me out of the loop and you didn't tell me what was going on." Now, that could be true and unrelated to speaking Spanish, right? He could have said, "What just happened? What are you doing? I'm your captain. I need to know what's going on," right? So maybe he told him, maybe he didn't. Maybe he said, "You don't need to know." We don't know. There's always two sides of this story.
Absolutely. Yeah.
That sounds not as good. So it's going to get you past a lot of motion work, right? He alleges enough. In any event, he was the following day after this, he was sent paperwork indicating that they were going to take disciplinary action for him. In 2003, he was given notice of a pre-disciplinary memorandum and process. He was placed on a leave. And he claims because of all this, I developed PTSD, which he has to claim because otherwise you have no damages necessarily for some of these claims. He said he was then ultimately in January of 24, he's discharged in retaliation for his disability and his discrimination against his national origin. And he claims that the HR and the city or whatever didn't protect him. And so this all now is going up under the Americans with Disabilities Act, race discrimination, race and national origin, wrongful discharge. It's all going through the federal court. So the interesting part about this are those facts. But I think it's really interesting because I could make up, our own facts that give the other side to that.
Right. Yeah, I think that, it'll be interesting to see how it all plays out. But I think that the initial allegations, and when I was reading it about, him being injured at third or fourth week of the academy, and then, but they, they let you back. I mean, they didn't wash you out. They let you back. Okay, so how much did they hate you? And but certainly now the allegations about not speaking Spanish. Now there may be a lot more to this as well, and we know that sometimes when people are burning bridges in the firehouse, and they say, okay, well, that'll be a good one. I'll write that one down. He said this, and said that there's some cherry picking of the facts. Now, whether or not he's the true victim of harassment and discrimination in the workplace, or whether or not he's cherry picking some things that happened to say, yeah, that's good. We can allege that. We'll see. It's got to shake out through the process and ultimately at trial.
And we wouldn't even know now because normally a motion to change venue from state to federal court is filed before an answer. So, because you got to know where you file answer. So we don't even have their response yet, which is just going to say admit and deny, right? But, so you don't get a lot even from an answer because it just says, deny. In federal court, a little more specific on the pleading requirements. But nonetheless, right, we'll see this. But I will bet you they say, yes, what he said is true, but he didn't give you the whole story.
Yeah.
Who knows?
That would be pretty common.
Yeah, exactly. And not shocking at all. Okay, let's go to Wausau. This is just disturbing. We have a division chief, and where's Wausau? I know a couple.
Wausau, Wisconsin, right?
Wisconsin. Oh, okay. So we have a division chief, and how they caught it is what's important and a very good lesson. So he's been arrested and charged in connection with the theft of controlled substances from the department's supply. He's been arrested on 3 felony counts of misconduct in public office, 2 misdemeanor counts. They could have kept going, right? This involves a controlled substance. They limited to, they could have kept going. But here's how he got caught. So he's alleged to have diverted 486 vials of a drug I can't pronounce, right? Hydromorphone.
Just morphine.
Yeah. And 600 vials of fentanyl, 612 vials of fentanyl. But compare that. So in 23, right, as opposed to 486 vials, they used just 11.
In less than 6 months.
Jesus,
in less than 6 months.
They use less than 5% of that number. And then as opposed to 612 vials of fentanyl, they had previously only used 22. That's
92.
a big deal.
92? Is that
92.
a typo?
Well, you said 92.
It says, doesn't it say 92?
It says 92.
92. I thought you said 22.
Oh, no. Oh, I'm sorry. Well, who knows what I say these days? But it's 612 compared to 92. So, I mean, but here's the deal. I want to know how they caught them because, right, somebody obviously is ordering a lot and saying, Jesus, we've never gone through 80 times the amount normal. So whoever caught that, smart, right? Kudos to them. That was huge.
It's funny. What's funny, a lot of the theft that we see in this area is coming from medics.
Yeah.
And we expect the chief of VMS to be the one that is keeping track of the medics. And here, fortunately, it looks like someone was keeping track of the chief of
Right.
VMS.
Whether it's the quartermaster or somebody else, but he's pulling them not from the kits, I presume. He's pulling them from the controlled
Oh,
stock.
I'm sure. I'm sure it's from their inventory, right?
To me, it was stupid. But if he has a drug problem or whatever, who knows? Maybe he's just desperate and doesn't care. But
Get him the help, and
yeah, yeah. Well, he'll get help in jail. Okay, and then the bombshell, and I'm sure I'm going to piss off all the some truck manufacturers with my comments, but we have
It's
Lacrosse.
outrage. What's going on? In my opinion, what's going on is absolutely outrageous. These people have no shame when
No
it
shame.
comes to the
In
price
our
of fire
in our
apparatus.
opinion, they have no shame.
That's
Right?
in our
That is our
opinion.
opinion.
This is unbelievable. The increase in prices of apparatus is astounding.
Yeah, so let's headline the lawsuit first, right? So we get the city of La Crosse, Wisconsin, who purchased a fire apparatus, so they are personally harmed, but they just filed August 20th, 25, as usual. You're Johnny on spot with stuff, but they've sued Pierce Manufacturing, Rev Group Inc., right? Because they're also Oshkosh, whatever, the financing group. Rosenbauer, America, even though Rosenbauer is also out of Germany, I think, and Fire Apparatus, and the Fire Apparatus Manufacturers Association, FAMA, we're going to use that term a couple times. So they say these three companies account for 70 to 80%. I'm surprised. I'm not saying they did it, but I'm surprised. Other big ones, Sutphin are big ones, Seagrave are big ones, right? And in Wisconsin, there's two. Pierce is there, and there's another one who's in Pierce. And let's see, I think Pierce is in Appleton, but there's a second one. Remember, because you and I talked about a lawsuit against them. It's not Seagrave. I'm forgetting who it is. I'm sure somebody on here knows. Feel free to comment. In any event, there's another major one in Wisconsin, but here they claim. They don't claim, they're dead freaking right. We all know this is true. They're alleging under antitrust, and they said that prices of, for an engine, right, 500,000 in the mid 2010s is now $1 million. And they're wrong when they say 2010. 2019, pre-COVID, a very expensive engine. I know this because I do a ton of bond counsel work. So we're fine, doing bonding for this stuff all the time. A very expensive engine in 2019 was about 650,000, right? A very expensive engine. And it's now well over $1 million.
1.2 million to get an engine now, an average engine.
And 3 to 4 year wait, right? And so, and then an aerial, right, which used to be 900 to 1.2 is now 2122. So, and the delays, an aerial is about a 4-year delay. So they allege that they conspired, violating the Federal Antitrust Act. I'm going to talk about that. And, they say it's hurting everybody. So they're going to potentially, I wonder if they're going to get certified as a class. I'm betting they do.
I'm betting they do. I hope they do.
I hope they do. So when this first started, and I want to bring out two things. When this first started, after COVID, aluminum went, and I believe these numbers are correct, from $500 a sheet of aluminum to $1,500, right? And the costs or the delays, right? They claim pre-COVID or post-COVID, well, we had to close manufacturing plants. We don't have the labor, but these are highly skilled jobs in many cases, right? And they claim, oh, we lost labor because of COVID. Now, maybe they did, maybe they didn't, but that's part of the suit, that they've imposed long delays. I don't know why. I'm not sure the benefit of why you'd want to impose long delays, but here's the thing. Aluminum has returned almost, right? It's not $1,500 a sheet, I don't believe. And we've seen all these material shortages have remediated themselves, right? But now they keep doing it. So I had a client in New York, I'll say middle of the state. They had this vehicle from, I could look it up, but it's from the other Wisconsin and manufacturer, and they had a contract, and they're delivering the truck, and they said, we're not going to deliver it, and you give us another $600,000. You might remember this because I said we're going to sue, and I called the company and said, I'm suing you for breach of contract. I said, we have a contract, you have to deliver. They said, well, we're not going to deliver it unless you give us another $600,000 on top of whatever. They said, we can't afford to make it. I said, that's your problem. right? Not ours. We have a contract. I feel like Jerry Seinfeld. I don't think you understand the point of a reservation. So, right. So they refuse. Now, ultimately, I got it another way, got the money back in a different, we bought another couple engines, they reduced the prices. But where the heck did that come from?
Mhm.
So let me talk about elements of antitrust from the Department of Justice, because this is who will come in. I have been begging states' attorney generals to do something about this, as have others, quietly. So to establish there's criminal violations and there's civil violations. I'm wondering if the DOJ will come in and allege criminal. This is civil, not right, because a private citizen can't enforce civil, but listen to the criminal. So, and it's very much like the civil, by the way, right? Civil is simple. You conspired with others who control a majority share of the market to affect prices or key elements of the purchase as to restrict a fair and free trade. That's said in a layman's terms, right? But that's what it is. And when they allege that they control 70+% of the market, then that's right. They've got it. And if they conspired, they may have it. Now, they're going to have to prove there are valid reasons why there are delays and price increases. But here's what I want to know, and I expect this to follow suit. I wonder if the DOJ will come in, right? And Trump may, you never know, right? Because Trump's controlling the DOJ. Here's the three elements of the criminal side of this, right? One, the charged conspiracy was knowingly formed and was in existence about time of the alleged acts. The defendants knowingly joined the conspiracy, right? So they all got together, and the conspiracy was either substantially affected interstate or foreign commerce. Well, it certainly does. Fire trucks are on the road, and occurred within the flow of interstate or foreign commerce. They could come in and say, you are restricting trade, violating, public safety, et cetera. People can't afford this.
Right.
And what are you supposed to do? People are waiting. Okay, we wait 20 years for a new engine, 20 years for a new aerial, and now you got to order it 4 years in advance. I mean, that is insane at twice, 3 times the cost.
Yeah. I mean, there's so many parts to this. And I also wonder how long it's going to be before we see a comparable suit with regard to turnout gear, because those prices are insane.
Yep.
Absolutely. What used to be $3,500 not that long ago, pre-COVID. Now, the last set that we just bought, $8,500.
A set?
A set.
Oh my God.
35 to 85 over the same time frame we're talking, 2018, 2019 to
Right.
this is insane.
And so they've created this monopoly. Now, yes, they and here's the thing. This is the problem. There are a ton of third-party vehicle manufacturers, not as many as pre-COVID. And look, if you want to buy a tanker, right, or a tender, sorry, right, it's not that hard. You want to buy some
apologize. It's a tanker.
Yeah. So I don't want the the wildland people to get upset at me. But nonetheless, but there are a lot of other manufacturers, but these are the ones. Now, here's who I think also gets involved. I don't think Wisconsin went far enough. So there's all these public Sourcewell, HGAC, these public bidding, and they're allowed by state law. They bid fire trucks, right? But guess who is pretty much all of the bids? It's these same people, plus some others, but these same people. So their monopoly goes way beyond this market share. If you want to avoid bidding or whatever, but everybody has then raised their price, and now they're doing it again. They just said, "Oh, tariffs." Wait a minute, you're a U.S. manufacturer.
Any excuse to raise the price and have cover, But I know the diesel emissions have recently been increased, and right, and that has caused. I know a friend of mine runs a company where he's got a bunch of diesel trucks, and he's been complaining about their costs going up, not nearly as much as fire apparatus, but some of it's been related to the mileage concerns and also the diesel exhaust things. Now, from what I understand, the current administration is talking about rolling back some of the, if not all of them, rolling them back, which may provide some relief as well. But also, I did want to point out, I did a little bit of research on my own too, in terms of antitrust law, because I said, well, 70 to 80% of the market, that's not really a monopoly. It is 70% is the threshold for a monopoly. So I'm not sure, what the actual numbers are going to turn
They
out to
could have
be.
just included one more manufacturer in here, and they would
They
have
could
had
have,
it.
yeah,
I mean,
yeah.
but here, here's the other thing, and in my opinion, this is part of the sham. So remember, I represent about 500 fire departments, so I'm hearing things from people who are buying trucks. Every one of them, every single client, almost every single client, just be safe, calls me up and says, "We need you to get this done fast." And now I'm saying, oh, because the price is going up at the end of the month? That's what they told me. Every single
Yep.
month, these manufacturers are telling them the prices are going up if you don't bid it in 30, or you get us the contract in 30 days. Okay, that went from a sales tactic to a straight out sham. And if they really are raising it every month, I hope you lose this lawsuit, because there's no way that every business every month, and we're not talking 0.5%, we're talking 8%, 10%, 30% increases every year, every month. This is not not defendable. And the
Yeah.
attorney generals are sitting on their proverbial butts. They need to get into this. And by the way, I hope everyone caught the New York Times article on this. The New York Times, oh yeah, pull it up. New York Times did a huge story. New York Times or Wall Street Journal, it was one of the two, about 45 days ago on
Oh,
this
really?
exact issue, not this
Oh,
lawsuit. They caught it, and they talk about maybe this was their basis. You should pull it up. And I asked everyone, either Wall Street Journal, New York Times, no more than 60 days, probably 45 days ago, talked about this exact issue and even called it an antitrust issue.
yeah.
So
Well,
we're going to watch
I
this. This
just
is not
I
going to go
can't
away.
believe. I mean, I don't know how fire departments are supposed to afford $1.2 million for an engine.
Or 2-1 for an aerial?
You
Come
know,
on.
it's just that's especially career city departments. Certainly, they're up against it tax wise, but volunteer fire companies. I mean, how many chicken dinners or spaghetti and meatball dinners
Right.
to pay 1.2 million? And this is how are you supposed to do it?
In our opinion, this is a sham. In our
Yeah.
opinion.
I just, if not, I mean, and let's give the devil they do. There may be some legitimate reasons for some of this, and we'll see, do they add up to the
I can
point
defend some
where,
of it.
yeah,
So
do they add up to, or are they taking advantage of excuses to, line their pockets?
So
But this
part
is,
of their defense will be, remember, many trucks, many vehicles are made up of third-party components, the
Mhm.
seats, the
Right.
harness restraints, the pumps, right? The nozzles, the everythings. And those are coming from third parties, right? You spec it with a third party. I want a Darley pump. I want a Watrous that. I want a
Well,
Hale that. And if they suffered, right, if they're handing over increases, that's where some of it gets it. So some of it is defendable, but 100% increase?
I'm suspicious of the role of venture capitalists in buying up these
Read
rich,
the New York Times article,
you
because
know,
that's what they talk about.
because what these corporate raiders or whatever you want to call them, venture capitalists, they come in and they'll buy a family-run business, and then they're just saying, "Oh, we're gonna do this, we're gonna do that, we're gonna," and intending to make it more profitable for the people they're going to sell it to. But in the process of doing that, what was an affordable product for the fire service now is just, where
Yeah,
it's
this is weird. February 17th. Okay, so my timing sucks apparently. But February 17th, 2025, the New York Times does an article which you can find called "As Wall Street Chases Profits, Fire Departments Have Paid the Price." And they talk about fire engine manufacturing is now largely controlled by three companies. Prices have soared and ordinarily could take years. So
shoot me
read
that
that
link.
article.
I'll include it in the links with this video.
Yeah, and unfortunately, you've got to have an account
Oh,
to do
okay.
that. But if anyone has a Times account, but I just sent it to you, and people should read it. I guess time really flies.
Yeah.
It was a while ago, but here's the point, and I hope this resolves itself favorably to the taxpayer and the fire department.
I do too. Something's got to give. I mean,
Right.
something's got to give.
And I cannot say enough for all the fire truck manufacturers that are now pissed off at Curt. It's my opinion. That is our opinion.
Well, I'll say this is John Murphy signing off, and
Yeah. There you go. And
and
myself, Chip
and your
Comstock.
chips and Chip Comstock is with me.
Hi, everybody. That's all we got, Curt.
So, well, all right. Well, I guess that's going to do it now for Fire Law Roundup, and
That was a hefty
we'll see
roundup.
what the apparatus manufacturers want to go to war over this. So,
Right.
all right, man. Well, thank you, and we'll see everyone again next week, and
Happy
that'll
Labor
do it
Day,
for another
everybody.
edition.